because I've mentioned Wales there, let's talk a little bit about GHP for a minute, if we would, please, because you yourself, you're not based in Wales at all.
I'm not based in Wrexham, no, I'm based
No,
in
you're
Oswestry.
in Oswestry, so you're in Shropshire girl. Shropshire girl, you really are. But because we're broadcasting from Wrexham, GHP do have, in fact, it's probably their head office, is it? In Wrexham?
Head office in Wrexham, yeah.
Thought so. Which is on what street?
Grosvenor
Road, indeed.
Well, the solicitors seem to be.
Indeed, they are. Yeah, they all congregate in the same area, don't they? They're obviously happy like that.
Yes.
It's like fast food places, isn't it? They all stick together. Would you say there was a similarity? No.
I'm sure they'd love me for likening them to a
Like Kentucky Fried Chicken. Oh my goodness, we're giving free adverts away. We're not allowed to do that, really, I'm sure. Right, so, but you have these surgery days. I love these surgery days. These surgery days are very popular with people. Can you remember off the top of your head what day of the week it is in Wrexham?
It's Wednesday. I had a feeling in Wrexham it was Monday.
I think it's Monday. I think it's Monday. So I think between the two of us, we've got it right. Yes. Okay. So it's
in the next interlude.
Yeah, you can. We'll correct it if it's wrong. Yeah, but we're pretty sure that it's Monday, and it's between roughly what time?
I don't know. I have to be honest.
It is
12 o'clock.
I was going to say.
Over the lunch hour.
I thought it was 12 till 3 or 12 till 2. So therefore, between the two of us, we're getting there.
Yes,
okay.
yes.
And people can just pop in because of the demise of legal aid. This is a great facility and service that you and other firms of solicitors, I might add, offer, because people can just come along and say, listen, can I please just sit down and talk to a solicitor, fully qualified solicitor. I've just got this issue, and you will steer them in the right direction.
Yeah.
There's no charge. At that stage, you're either going to say, listen, you do need legal representation, and this is how you should take the matter, or you will say to them, look, you don't need to be worried about that. Move on, Go and chop the tree. Go and chop the tree down and just throw the branches over on your next door's garden.
It tends to be only certain subjects, I have to say.
Of course it does.
It tends to be the more civil.
Yeah, of course it does.
Mitigation issues such as boundary disputes, if it's related to your family as well.
Yeah. I was going to say that the very, very early stages of matrimonial, people sometimes need immediate and early advice. My husband's just left and he said he's going to sell the car and he's going to sell the house and I'm not going to get anything. And that person then needs to be told, hang on a minute, he can't do that. So let's just...
Children or any
and in those initial arguments, it's very frightening to someone who doesn't understand the law. They're literally, well, that's what I've been told she or he is going to do. Well, they can't do it. So it's a reassurance to people like that, aren't they?
It's initial, no cost involved, consultation, and obviously if the solicitor feels you need to take it further, they will give you advice, and you can then talk about fee arrangements and so on and so forth.
Of course,
So there won't be any initial charge, but if it's felt that it needs to be taken further, then obviously you can make a decision at that point. And you can arrange some kind of arrangement. With
of course you do. Yeah.
I mean, there's all sorts of things we do nowadays. It's not a case that you have to pay a fee up front.
No.
There's contingency fees, there's conditional fees. I don't profess to know a lot about it because I don't get involved because I'm a private client solicitor. Yeah. But certainly, if it's not a case that you're going to have to suddenly hand over all the money. No. Discuss it with the solicitor concerned, and they can come to some kind of arrangement with you. So.
Yeah, I just think the surgeries is a lovely way that people, when they're aware of it, they can just feel relaxed that they're just walking into a room where they're just going to ask for initial advice, and they're just going to meet a friendly face.
I mean, and they know they're not going to get handed with a big bill at the end.
Yeah, you laughed when I said the friendly face. I was just about to chip in there. Said, do you do these yourself? No. Well, there we go. That proves the point. Because yours in Oswestry on a Wednesday, is that right?
On a Wednesday, yeah.
Wednesday.
Between 12 and 2. So,
Right. Okay.
But no, it doesn't cover my area of law, but it does tend to cover, like I say, civil litigation. So you've got a boundary dispute or a debt problem, or you've got a family problem, something like that. Then it covers those two subjects.
Okay, landlord problems. Could be all sorts. Anything. Yeah, okay. Right, moving off that then, gently and swiftly and quickly, all in one go. Disputed wills now, where somebody's written a will and they've said they want everything to go to the dog's home, which wouldn't be a good example really, but it could be they wanted everything to go to one person but one beneficiary, and another beneficiary is going to step in and say, no chance, I don't believe that my mother was of sound mind when she wrote this or whatever. So go on, what is the process if you wish to dispute a will?
Well, there's a few grounds upon which you can actually dispute a will. You can dispute it, as you've alluded to, on the grounds of lack of capacity, which means they didn't know what they were signing when they signed it.
Yeah.
They can dispute it on the grounds that possibly you were unduly influenced in writing the will, so whoever's named as a beneficiary has put undue influence upon the testator to write it in the way that they have.
Okay.
That's another way of going about it. If you didn't want to dispute, so if you accepted the validity of the will, but you still felt that you should have been left something out of the estate, you can go along the lines of a claim under the Inheritance Provision for Family Dependents Act. And what that is an act which names a class of people who can make a claim against the estate if they feel that reasonable provision for their maintenance hasn't been left under the terms of the will.
Oh, right.
So they accept the will, but they think they should have been left something.
Right.
So there's two different ways about it. As I say, you're questioning the capacity of the will either because you think the person didn't have capacity to do what they were doing, or that they've been unduly influenced when they did it. Yes. Or alternatively, you accept the will as it is and say, well, I should have been left something, and now I'm going to make a claim under this act because I haven't been left something.
Oh, that's interesting.
So those are the two different ways, and usually you tend to find that the claims are interlinked, so they'll either claim that they didn't have knowledge and approval when they made the will, but if that doesn't succeed, then I should still have been left something.
Wow, yeah, that is a double prong. Yeah.
So from my point of view, when I'm making a will, quite often you can foresee the ones that are going to open.
Of course you can. Of course you can. Yeah, of course you can.
So, particularly in light of a recent case called Illit, where a lady left her entire estate to charity and completely excluded her estranged daughter.
Right.
That case actually succeeded. She brought a case under the Inheritance Provision for Family Dependents Act and said, well, mum's left it all to the cat's home, but I should have received something out of the estate. Yeah. It actually went through the Court of Appeal, through the High Court, and so on and so forth. And eventually came back, she was awarded something out of the estate.
Really?
But yeah, the main bone in contention on that seemed to be that it wasn't so much that whether she should or shouldn't have been left something, it was it was quantifying what she should have been left. And I think it ranged from 50,000 in the first decision up to 148,000 or something similar to that. Wow. And then it came all the way back down to 50,000 again. Right. Okay. The judges couldn't agree on quantifying what she should have been left. But unfortunately, it does mean that the floodgates have kind of been opened. Yeah, because of course. There's something. Oh yes. Other relatives have now said, "Well, okay, it's worth a go." Yeah, we're going to use the particular case. The decision. Yeah, because I think it's pretty appalling from my point of view. I'm sitting here thinking, well, if I wrote a will saying that I wanted everything to go to the cat's home, then assuming I was of sound mind at the time, which in my case is unlikely, but anyway, but if it was, then that is what my wish was. Yeah. And I don't want somebody to come out the cracks in the woodwork and say, but he didn't really mean that. He meant that he wanted to leave me something as well. Yeah. So this is going to open a can of worms. It does open a can of worms. It's not so much the testator's intention. It's not that they intended me to have something. It's the fact that they, because of their relationship with the deceased, that they could have expected to have been left something. And it's the wording is reasonable provision for their maintenance. But that depends whether they're estranged. If they're estranged, that lady who passed away may have said, well, the very last person in the world I want to have is my daughter because I'm so appalled that we're estranged. The daughter in that case had eloped and got married at a young age and hadn't had any contact with mum for years and years and years. And she'd actually also done a declaration with the will to explain why she'd done it. Yeah. And even then the courts were willing to grant the daughter something out of it. Sorry, don't agree with the courts there. No. I'm not going to... Of course, there's supposed to be such thing as testamentary capacity, freedom of testamentary capacity, so you can leave it to whoever you want. Yeah. Unfortunately, this act does kind of cast some doubt over that. And in fact, I've had a couple of mine that have actually been challenged after the fact. Yeah. That must be quite worrying for you from a professional point of view, because in fairness, you've given me advice, I've passed away, and now suddenly all the advice you gave me has gone out the window because somebody's alleged. So. Yeah, and the difficulty you get is that you get a letter from a solicitor, and it is quite unnerving when you get a letter from the solicitor. Of course it is, Under what circumstances the will's made, who made the appointment, was anybody else there when the will was made? What steps did you take to make sure this, that, and the other? It's suddenly... You're in the firing line. Yeah. So as I say, you tend to know which ones are going to cause the problems.
Of course.
So you try and take steps to preempt that. So, for example, if you think there's possibly a claim that's going to come under the incapacity argument, then you'll get a letter from the doctor,
of course you will,
specialist,
to back it up,
to say that they had capacity when it was
absolutely
done. If
you
think there's going to be some issue about undue influence, you try and get a statement from the person making the will to explain their reasons, to make sure that. And similarly, if you think there's going to come a claim under this Inheritance Provision Family Dependence Act, you will do likewise. You will get a statement to say, I've carefully considered the circumstances. The reason I'm not providing for my son or my daughter or whatever is because of this. The reason I've chosen to decide, to leave it to whoever is because of this. And then hopefully somewhere down the line you'll manage to sort of curb it, if you like.
Absolutely. And that would be like on a separate memorandum, I assume. It wouldn't be part of your will. It would be no.
The declaration in the will to say the reason I've not provided for whoever is because of the reasons set out in the memorandum.
Thought so.
And then you have a detailed note of why.
That's fine.
Why they've done what they've done, and from our point of view, we've got to make sure that the testator is consistent with their instructions. Make full notes. I mean, the files that used to be a couple of pages long years ago, and now can be pages and pages and pages.
This is why my argument is that unless you've got the most straightforward of situations, and go back to husband, wife, two children, 3-bedroom, semi-detached house, etc. Not many of them exist, but if they do, maybe there's an argument to say, well, yes, that's straightforward. But even then, brother and sister can dispute and argue after you've gone, so therefore, but any other type of complexities, you must get a solicitor. Well, I'm saying this, not you, but you must get a solicitor to write the will, because to write it yourself is almost foolhardy. That must come across occasionally where somebody's actually written a will and it's really caused more of a problem because I bet it has. I bet you have. So in fairness to them, in good faith, they've thought, I'm going to write my own will, and actually it's created a bigger problem when it's actually come to their death. So I can believe it.
Word out of context.
Can
change the whole.
Of course it can.
Context of what their intentions would have been, and it can cause all sorts of problems. Or people, I've seen them before now where they come in and said and just cross bits out and they've written something else but well, that's fine.
They've had a change of heart halfway through. Hang on, slow down. I mean, it is an intensely important legal document without any doubt at all. I've said it many times, but the cost involved in doing one, I think you're better off doing it. But absolutely,
again, for the very reason that possibly you could have a claim against the estate somewhere down the line. And the amount of times I've had people say to me, I never thought of that. I never thought of that. And then they perhaps considered doing it a different way. It's nobody's business. So but certainly claims against the estate, I think, may well be on the rise because of this ILLIT decision.
Right.
I think more people are willing to give it a go.
Of course they will.
And see what they can get.
Hey, there'll be solicitors out there that will be enticing people to say, listen, if you've got a situation, let's have a go at it, It's a difficult one for me because I'm sitting here thinking, if the person has written in sound mind exactly what they wanted, and then it can be disputed, it just makes, and then you start losing faith a little bit quickly, don't you? Where you think, what type of judge is going to sit there and go, well, I know he said that, and I know he put it in writing, and I know he's written the absolutely everything right in his will. But you know what? We're going to say he didn't really mean it, because that's what you're disputing, isn't it? You're actually turning around and saying, but I don't think he really meant what he said, or she said.
Not even that, though. You see, this is what I'm trying to get at. It's not even whether they meant it or what their intention was.
Right.
It's the fact that the person bringing the claim, as far as the court were concerned, should have been left something because of...
but that's still in direct conflict to the person who's actually written it, saying, no, they shouldn't, because you don't know all the circumstances.
They're questioning the interpretation of the will. They're questioning this person has been excluded and they should have been included.
Because, how do you make that decision? Wow.
It's not, and I have to say, I don't tend to get involved in the contentious.
Right, okay.
As soon as it looks as if it's getting... to that situation, I hand it straight over to the Civil Litigation Department.
Right, okay.
But as I say, from my point of view, my role is mainly when I'm making the will, if I can foresee these problems, making sure that our file is as watertight as it can be.
Absolutely.
At the end of the day, I tell clients, I can't sit here and give you a cast iron guarantee.
No.
That if the claim comes, it's not going to be considered, because I can't do that. Unfortunately, the way the Inheritance Provision of Family Dependent Act works, that person can bring that claim.
Yes, yeah.
Yes, they would have to persuade a court that they should have been left something.
Absolutely.
But there's nothing you can do to stop them from
No,
doing that.
no, they can take the claim, but all being well, the pieces of paper that we've drawn up today are going to mean that actually they haven't got a good case, and all being well, a solicitor who who acts for them is going to read through everything and say, do you know what, you're going to spend a lot of money and get nowhere with this. All being well.
So
all being
that's usually the best we can do, is just make sure that our file is as full as it can be and our notes are as full as they can be and that the evidence is there.
Yeah.
To try and make sure that if that claim does come, then we've covered every possible scenario. And unfortunately, those situations are becoming more and more.
Of course they are. Well, that's because of the size of people's estate.
Yeah.
Money.
Yeah.
You know, it always breeds the worst in people, doesn't it?
That's unfortunate.
Okay, right, well, we shall have a bit of a break now and listen to Mr. Phil Collins every day. Then we will be back to say goodbye to Vicky, because look at that. Where's the time gone there? Goodness me. Okay, we'll be back in a minute to say goodbye.